My name is Lawal, Chairman Young Lawyers from Ibadan branch. We are here on this session with the topic courtroom ethics. With me, my learned friend, the chairman of the board of legal assistants, Mr. Epong J. Epong. The board is the one saddled with the responsibility of ensuring that these interview sessions with our seniors have been facilitated. Also, the PRO of the forum, Madam Bola Awere, is also here with us. And it's also a privilege to have the chairman of the Premier Bar, the Nigeria Bar Association of Ibadan branch, Mr. Ibrahim Lawal with us. Also the head of chamber of Uludrimi and Akeredolu. We are here to discuss the topic courtroom ethics, particularly with respect to giving orientations to young lawyers, because the bar of then is beginning now to look now not like the bar of now. There are so many ethics that are being short of standard. So proceed to the interview, and then we'll start with introductory questions for the chairman of the MBA Ibadan branch, Mr. Ibrahim Lawal. I would also want him to, before we commence fully into the interview session, to if you give us a word or two with respect to this program that young lawyers are trying to, the Young Lawyers Forum is trying to ensure that we are bringing knowledge from reputable seniors closer to members of the forum through the internet. Thank you, sir.
Yeah, let me start by commending the Young Lawyers Forum Ibadan branch for this laudable efforts. Laudable effort in the sense that there is need for us to document our programs, our activities, and in order for future generations to benefit from it. A lot has been done in the past, but because there is no documentation, it has frittered away. So I think it is important that we consciously document whatever we are doing, in such a way that even when people want to write the history of the bar, they have resource materials, to look into. So it is in this wise that I want to commend your initiative, particularly on sharing knowledge, because we are in a stage where a lot of things that we met, a lot of traditions had been thrown away. And from time to time, we need to remind ourselves. Like I always say, our profession is rooted in tradition. And if we don't understand the tradition, we'll continue to fall into the abyss. And that is why a program of this nature is important to also bring into focus what is expected of those that are coming behind us. It is not by happenstance that more often than not, you have orientation programs, even in the universities, to tell us our do's and don'ts. And we also do a thing like that, even when new members join us, to also tell them what is expected of them at the bar. So I think I commend and I support this laudable program for the fact that it is going to also bring back that synergy that we have between the old and the new generation.
Thank you, sir. We are very much grateful. Chairman MBA Madam Branch, Mr. Ibrahim Lawal. So quickly swinging into action, I like to put a question to you, sir. It is a known fact that, particularly with respect to the topic for today, courtroom ethics, it is a known fact that proper appearance before the court is being regulated in the profession. Could you please, for the purpose of clarity, state to us the standard mode of dressing for lawyers to appear in court, the standard in higher courts and lower courts?
Yeah, thank you very much. I think first and foremost, for you to be a lawyer, everybody knows, even from the university, we know the kind of dressings that is acceptable. White over dark trousers. But emphasis is now on black, because when you now say dark, they have misconstrued it. So it's now black, and black tie or blue tie. But most of the time, black tie and black shoe with black socks. That is if you are appearing at the lower court, at the magistrate court, or any court that you are not supposed to roam. If you are going to the High Court, Court of Appeal, or Supreme Court, let's start from your suit. It should also be black suit, white shirts, with your collar and your bib. Most of the time, you see lawyers donning wing collar shirts. It is not too good. We have some courts that will tell you they will not accept wing collar dress. I have a judge in Ogun State, in Abeokuta, where you cannot dress that way to his place. You have to, and when you are called to back and you put on wing collar shirt, you put on your this thing now. And so when you get to a level of your practice, you don't even wear suit to court. You put on the lawyer's jacket and the striped trouser. That is the standard in England. And for those who know what is something one should emulate. I think about 3 years after my call, I stopped wearing suits to court. I had to go and buy, because when I see a Katie dress to court, I feel enamored. So that thing encourages me to also do same. And not only that, you just put on white that will look like brown. Your white should be white. And the thing is that it is not compulsory, it must be expensive. But what we are saying is that you must keep it neat. When they see you and you dress neat, even your appearance in court, judge will want to listen to you. But a situation where and the bib must be well ironed, not just the bib that you have put somewhere. It would have been wrinkled. So, the way they will even dress, you see lawyers appearing in court, you feel disappointed. Then you see some lawyers, they will put on shoes without socks. It is common to the Gen Z. I know, even when you put on suits, they don't put on socks. I don't know whether it is a fashion. They don't, and it is wrong. And some of them that will put on socks will put on red socks or yellow socks or blue socks, things like that. It does not depict us as a very responsible person. That is not what we meant. And we must strive hard to ensure that we dress the way we met this profession. Some of us got attracted to this profession by the mode of dressings of lawyers. When we see them, the way they dress, the way they carry themselves, we got attracted to it even before we look at what they do in the courtroom. That appearance alone, attracts a lot of respect for one. So one of the things about courtroom ethics is the proper dressing of a lawyer. You cannot dress shabbily as a lawyer. There are certain standards expected of you as a lawyer, and your mode of appearance is very important. And that is why even in the campuses, law students are, recognizable by the manners of dressing. When you have courses with other students that are not law students and you are just coming from your faculty, you see the way you guys will appear. So it is very important that we adhere strictly to that mode of dressing. It's supposed to be dark, whatever, but because of the abuse, we now insist it must be black so that there won't be any issue as to what is the proper mode of dressing.
We are grateful, sir. That answers that. And another question, I like to quickly deviate from the courtroom ethics being the topic, because one of the reasons why we are choosing to address this topic is because of your bluntness for truth. Particularly, this is also with respect to dressing, but outside courtroom. Some young lawyers have the view that when they are going to law enforcement agency cases, when they are going to meetings, land matters, they can dress in the best simple mode that they feel like, since it is not the courtroom. But from experience or by virtue of one or two things that has happened recently during your administration, I've also I've had this discussion with you to an extent. I also agree that the fact that you may want to go for other brief, which is outside courtroom, there's need for you to properly dress as a lawyer. I want you to please give few comments on dressing outside courtrooms to why you are also discharging your legal profession.
Yes, what we met as a lawyer from our seniors is that when you are going to court, after having dressed in your courtroom attire, you also have your suit and either in the office or in your car.
Okay.
So that when you are through with what you are doing, you change. That's why you have ruby room. In fact, the essence is that immediately you step out of the court, you go back to the ruby room and change to your suit. The thing is that when you get to any police station and you are on suit, even when you are not a lawyer, they first address you as a lawyer. Your dressing will give you out whether you're a lawyer or not. A lawyer cannot, because he's not going to court on weekdays, put on jersey and jeans and go to EFCC or police station or anywhere and say you are representing a client. What is the difference between you and that client you are representing if you appear the same way? So it is important that we know that lawyers are meant to dress well. Even when you are putting on native, you put on native and you put on your cap so that they will know that this person is different, particularly on working days. That's why if I don't want to put on suit, I have some other French suit that I wear that will also take me out of the crowd. So it is important that we take care of our appearance. Chief Babalola will say this, that a lawyer must take care of three things: what gets into his head, that is learning; what gets into his mouth, that's good food; and what he puts on, your attire. Because the English people will say you will be addressed the way you are dressed. So it's important that you cannot afford to dress shabbily as a lawyer. Our profession is a profession of how do I put it now? It's a profession of learning, it's a profession of respect, it's a profession of regard. And the way you carry yourself will determine whether you are going to be regarded, you are going to be respected, or you are going to be insulted. Not only insulted, assaulted. So it's very important that we put that. If you want to do guy on weekends, when you are not, you can put on your jeans, you can put, but you cannot, as a lawyer, you can't be struggling with others in terms of the way they also put on those dress. if you know you want to also be happening guys, which is, it does not take anything away from you, wait till weekend when you can appear casual, not during office hours.
Thank you, sir. We are very much grateful. I'm sure that members of the forum would have picked that dressing for lawyers outside the courtroom and in the courtroom is very, very important. You have heard from the chairman of the bar. We'll proceed. Before my colleague, Mr. Epong, has asked me to ask you, sir, I was hoping not to disturb you on that. Dressing, the mode of dressing for female young lawyers in
Okay.
courtroom.
Okay.
In courtroom, so
Yes,
that
yes. Okay, I've not addressed the female. Yes, I
yes,
thank you, Ekong, for bringing my attention to it. Female lawyers too, their mode of dressing should be um, black gown or this their skirt and blouse, white blouse, black skirt. They have also said even when they have outings, they can put on trousers, but it has to be black
black
trousers.
trousers,
And their this thing, this is it wing collar you call it,
collarette.
collarets, must be tucked inside this. So they must wear, apart from the fact that they are work gown, they must wear something that will also
Cover.
cover that thing. It's not that most women, what they do is that when they put on a gown like this, they put that collaret and now put
Jacket.
they put a gown on it without jacket. It is not
Mm,
right. You are supposed to have a jacket, that it is all under that jacket that
that
your
collarette.
collaret will be. But most of the time they just dress shabbily. Then, as a female lawyer, you cannot afford to do any hair style that will give you away like you are a songster. No, you must keep it low so that your wig can sit well on your head. You can't also have dangling earrings in court.
Go on.
It is not right. Dangling earrings or all those things. No, no, no. You have to keep it low. You have to keep it low. So that's and black shoe
Yes.
for women.
Black gown without that does not have a kind of net.
Net,
That's
yes,
not
now
revealing
that
and
is
not
not revealing
transparent.
anything,
Yes.
because in courtroom is a serious business. You should
Mm.
not be distracting. While some people who want to prepare for their cases, they get distracted when they see some
Yeah.
dressing.
Yes. Yes.
So
With a good level of length.
yes, so
Because
it has to at least let it get to be
the
let
knee.
yes above the knee, below the knee.
Yeah.
Uh,
Thank you, sir. We are very much grateful. Yes, I like to also go to the next question. As a lawyer and a young lawyer, which is first? A lawyer's duty to court or a lawyer's duty to client? Which takes precedence and why?
the lawyer's duty to court is very important, because court is a court of justice, and justice is not only for your client, it's also for the other one. And that is why it is important that even when they bring cases, it is not all cases that you take to court. And if you have chosen to go to court, your candor, and you must put everything before the court to ensure that there is justice. You must assist the court. You must not mislead a court in such a way that you mislead the court to give wrong judgment. So you have a duty to court to assist the court. So, and if you preserve that duty to court, you are already aligning yourself with the cause of justice. So it is very important. If you say you have a duty to your client, that means that you must win at all costs, even when you know that certain authorities are against you. You don't want to cite it, and it is helpful in that this thing. So you have a higher duty. While you have a duty to your client, you have a higher duty, which is a
To
duty
court.
to the court.
Yes, sir. Thank you very much, sir. We are grateful. Yeah, before we Now, another question, sir, that we have for you is still on courtroom ethics. The belief is that courtroom ethics is put from the bar and the bench. It should be complied with. Now, for courtroom for ethics, courtroom ethics, take for instance, a judge has breached an ethical standard or procedure. What is the body responsible with respect to sanctioning the judge? And for the young lawyers that will be, what is the body responsible with respect to sanctioning whatsoever ethical measure that might have been breached in court?
Well, the duty of every lawyer is to also observe and respect the court, and ensure that you wait for the court to, and if there are breach in respect of a lawyer's whatever, we already know that the body of lawyers, NBA, particularly if the NBA investigate and find out that that lawyer is in breach of those ethics, they can be sent to disciplinary committee. But for the judge, we have the GSC,
Yes.
we have the NGC. You write a petition. There are occasions where a judge did a particular thing. You can also report to NBA, who can take that matter up with the chief judge. More often than not, the NBA takes that kind of a matter up with the chief judge with a view to resolving or raising that issue. It is only when the issue is not resolved and it's a serious thing that you resort to writing petition. But most of the time, the lawyers will still report to NBA for the NBA to take up the matter. The judge himself can also petition, I mean, the lawyer himself as an individual can also petition the CJ if there are infractions.
We are very much grateful, sir. So another question is that especially for young lawyers, it's common within young lawyers. Judges are always in the midst of maybe moving an application, and maybe there's a mistake or no knowledge or ignorance, and the judge be like, "What's your year of court? Who's your principal?" and all of that. Questions trying to inquire into your year of court and your route, where you had your principal and the likes of it. Those questions, are there questions that are in line or that are proper to be asked by a judge to a young lawyer, that will be posed to young lawyers and young lawyers?
It is. It is because the thing about the law profession is that as the moment you are called, you are a lawyer, so you can appear even at the Supreme Court. So there are certain level of preparedness that is expected of every lawyer. And so when you go to court, more often than not, your people, more often than not, pick up fights on that day. There are some people that want to represent somebody. I read on your YLF, who is going to Oyo, or who can go to Oyo for me to go and so they might not even read the file. And you get to court and a lot of things develop. And you know that they will not say because you're a young lawyer. If you are facing a SAM, it is also expected that you will do your job. So if a question is put to you, it might be to also protect you. To say how old are you at the bar? If you now say I am so say okay, the judge might be lenient. So it might be asked with a view to understanding where you are coming from. So it might be to also inquire to know where you are coming from and the kind of person you are. So it is a proper thing to also know. They said know your customer, even
KYC.
in KYC. So he wants to know you. There is nothing wrong. If
Well,
you
yeah,
say, well, what is your year of call? Even in the Supreme Court, they ask us. Even at the Supreme Court, say, when were you called? There was the last time I appeared before them at the Supreme Court, the lawyer came late. And he said, my lord, I'm sorry I could not write my this because I came late. But he said, from where? You came and you are even telling us. How old are you at the bar? We have formed our opinion about your person. How will you come late? I was the first person at the Supreme Court. In fact, they opened the door for me. I slept. I will take flight to Abuja and be coming late. After my asuba, I face Supreme Court. He said, hold up. They said you are not serious. And they were lambasting him. You will feel sorry for the guy at the Supreme Court. The last time I was there.
Those are some of those, but it would have thrown him off balance. So our own question
That
is,
is well, it is expected. Let me tell you, there are certain things that is expected of a lawyer. The era of pampering will not avail anyone. Let me give you a personal experience. I did my law school internship with Olujimi and Akindolu. I was posted from the law school, and so I was there. So I got along with Aketi. He had likeness for me and everything. And they called me, when you are through, come and resume. So the moment I was called, I came back. Nobody did interview. You did do rigorous interview at Olujimi and Akeredolu if you want to enter. They didn't interview me. That first day, they gave me court of appeal fine. Ọlọ́run wà pẹ̀lú ẹ̀. So and I had to, prove my mettle. You understand? Because it is expected that you be able to. Maybe because by the time I became a lawyer, I was already a daddy anyway. So
the maturity was there.
so maturity was there and everything. But it does not matter if you know what you are doing. Even when you make small mistakes, it will still be pardonable. It is not for you to come to court when the court had sat and you don't even know. There are some that will be pressing phone and they would have called their cases they don't know. It happens. So whether something will happen or you learn by that kind of a thing. If you are harassed today, you go and sit down and look at. You see, the problem with people in this part of the world is that we don't do self-assessment. We just find excuse and say it is one witch or wizard in our family house that had. So we don't do self-assessment. Why did I go wrong? What could have been responsible? When you do self-assessment, you'll be able to know your feelings and you'll be able to work on it, improve on it. So it is not enough for people to say, Judge come is harassing me, is doing this. If you harass you today, go and prepare well. If you have your facts at your fingertips, you can dazzle a court when you understand the case you have been given to go and do. Some persons will just collect file, go and pick date and say we are asking for adjournment, and now say no, you are going on. Have you read the file? What kind of preparation have you made for your case? Even if they ask you, counsel, what is in this case? God save you if you go to Court of Appeal Ibadan and you don't understand the fact of your case, you'll be in trouble. Because they can say, okay, yes, what is there said? What is the issue about the case? And you cannot say anything. They will feel disappointed and they will lambast you. That is the truth. So it is not only young lawyers that faces that kind of a thing. Even old lawyers who do not also understand what he has come to do. You understand? So it is part of the training. Don't take it as an offense. When you are asked, what is your year of call? You will say it now. Don't get offended. Even when a judge appears unfriendly, don't worry yourself. Just keep your eyes on the ball and do what is expected of you. Do reasonable diligence. Make sure that you are on top of your game. You understand your case. And that when questions are posed to you, you can give reasonable answers to those ones. Then two, you must endeavor to endorse your file at every point in time. The unpardonable sin you can commit in Olujimi and Akeredolu is not to endorse file. You can do any other thing, we can pardon you. Because endorsement of file also keep you up to date with your case. So you can say, my lord, were before you on so date. But if you don't endorse your file, how do you know the date or what has happened in those? Even if you are not the one that was handling the matter before. So when they give you a file that is not endorsed, you know you are taking a risk. You need to ask a lot of questions before you agree. It is not the money that you should consider when you are doing. You must also look at, somebody will tell you, we want to move an application. Just go there. Where is the application that you want to move? It's not giving you anything. Say you should go and embarrass yourself in court, and you accept because you are sent 50,000. And so when they now begin to harass you, you now look. There was a guy at the court of appeal. He came as an appellant. He represented somebody. The guy sent soft copy to him, and he was looking at that soft copy. So they said, where is the record? Where is your this thing? Was looking at. He said, in this court, and they lambasted him seriously. So these are things that we must know, because it is not enough to say that judges harassed. I know that there are some judges that are irredeemably. A guy wanted a letter to accompany his SAN application form. The guy is in Port Harcourt, and he said that he reached out to me that he needed a letter from Justice Fadeyi, who came to as one of the parents. Said, don't bother yourself. He's one of the unreasonable judges we have. I cannot help you. He will not. She will not give now. So I said, she's not. Put me on record now. The guy. I said, don't bother yourself. I cannot go and meet her. So the guy said, thank you, and he closed it. So I will know that some judges are, but majority of them will still want to listen to. They will guide you. If you bet, like I said, prove your mettle, and do your best to prepare for your case, and make sure that you don't come late to court. When you walk in late, you had already biased the mind of the judge. And so when you make a single mistake like this, they want to pounce on you. So please make sure that you understand the case you have brought to court, and you are able to give a reasonable account of yourself, in court.
Thank you, sir. We are grateful, sir. Quickly, the issue of yeah, particularly in this jurisdiction, we have had cause to seen courts that have said that as a lawyer, if you ever use a phone in my court, it is going to be seized, even when you are using it to browse through the internet for the purpose of trying to cite necessary cases before your case is called. And the court will be like, you cannot use phone in my court, and that is final. If you use the phone, it's either you have to work out or it will be seized. Could you please give us your comments on that, on the issue of having to be available online for the purpose of maybe trying to give instructions to lawyers in the office, why your case is not yet called? Some courts would argue that it is a distraction to their own proceedings. Why? And then
Well,
lawyers.
let me say that the essence of not using phone in court is maybe when it rings out and it distracts the court. I do not subscribe to a station where I put my phone on silence and I was trying to pass information. My principal will tell you that when you are in court, you switch off your phone because it's a form of distraction. You switch it off. Chiboji will tell you, if you call Chiboji, you are wasting your time until he finishes from court. Be that as it may, this is era of technology where a lot of people consult their phone for cases and what have you. A few percentage use that phone for that purpose. A lot of your people will come to court and be chatting. I have sat close to a lot of them that they don't even know what is going on around them. And the reality about courtroom ethics is that you shouldn't be interested alone in what is going on in your case. In fact, when you listen, when cases are going, you can pick from what had been decided and use it on your own case. Maybe the attitude of the judge to a certain application that you also intend to make, and you saw the attitude, you can always talk to yourself and say, okay, I think this will not be necessary. But if you don't flow, and there are certain things that you also learn from other people's case apart from yours, and that's why I don't also believe in young lawyers finishing their case and jumping out of court. It's not right. It's not right. Some of us will still stay behind and watch proceedings, because it is those things that would enable you to also have gain more skills. Most of the habit we form as an advocate are things we saw not only from our principals but others that we have seen in action. But if you don't wait, you might not have that opportunity, particularly when matters are for trial. There is no point. I don't know your generation. The moment they take dates like this, they have jumped out. They don't want to know what is going on in that court. And you also see a court that is almost empty, and you pack your bags immediately, you finish your this, and you must not leave the bar when the court appears empty. And you see some judges will say, thank you, I know you waited because the court was empty. They will note it. Part of our responsibility as a lawyer is that if your matter is called, maybe the last maybe the last three matters, you still need to wait for the court to rise before you leave. You don't leave an empty court. You understand? It's
Yes.
part of it.
Uh, In view of your submission with respect to the court not being empty, could you please, for clarity purpose and so that young lawyers can speak from your knowledge, the number of lawyers that should remain for the court not to be undressed, that should be at the bar, the number of lawyers that should remain, because we have had instances where some courts would refer to 5 at the bar and some other will refer to 3. So there have been
The minimum of 5 lawyers. 3 is the court is already empty. 5. If you are 5, why can't you just wait for this? And if you want to, if there is a pressing thing need for you to leave the court, you must make an application to court for you to move out. Unlike when you are many and you wanted to even create way for people, you can go. Yeah, my
yes,
lord,
sir.
I would have waited, but because I have a pressing whatever, so they know that you understand the tradition.
Thank
You
you, sir.
understand?
Yes, sir. Another question I like to ask is the issue of mentioning case and calling case out of turn, because we have also been in court wherein members of our forum have in a way also not done well by the opportunity or the privilege to calling case out of turn. What is the standard when we have about 7 to 5 seniors? Is it to seek permission from the most senior, or the young lawyer is expected to seek permission from all the seniors present at that bar before uh, calling case out of turn? That is, if there is an extreme need or urgency for the young lawyer to leave. If not, we understand that it is expected for young lawyers to stay back because seniors are leave. But in
You
the
have to seek permission from all of them, because if you seek permission from the man alone, that means if the man calls his case, the next senior will call his own case. Those are the most junior. You need to seek permission from all of them who are your seniors. So it's a long this thing. You have to. So you cannot say I have sought permission from and you didn't seek permission from me. You cannot call your case before me.
perfect.
But the thing is that it has become an habit. It has become a habit that your generation just want to call their case and say it's not going on, sir, without reason. So that is not going on, sir. Please, can I just mention my case so that it is insulting. It is lazy. It does not also show level of learning. Something happened at the Court of Appeal yesterday. I sat. They were calling cases the SEND. Meanwhile, they have said the chairman of the bar, anytime you are here, just call your case out of turn. I sat. It was one of the staff that now told them that the chairman of the bar said, chairman of the bar, you didn't tell us that you are here. We didn't see you. Call your case. If it were some other persons that had been given that, they would have jumped off. But most of the time, I don't do it. It is the judge that will say, Mr. Chairman, what number is your case? It is better for you to be recognized than seek for recognition where there is none.
Mm.
If they woke up at the wrong side of their bed and say you are chairman, I say, so what? When were you called that? You have people who are, you understand? So it is better that you maintain your respect, except when it is important. There are some lawyers that will have more than 2-3 cases. That is understandable. But because your matter is not going on, so I should allow you to call your case out of. The way I will open my eyes, you will take a reverse.
Thank you, sir. We are grateful for that. And then, being the chairman of the bar, we don't mind if this is your own principle of ensuring that young lawyers who just want to say my case is not going on, I want to call their case. Your principle of always declining can also be communicated to other members of the senior members of the bar, so that when young lawyers that just want to call their case and go, they can be declined. That opportunity for them to call that case can be declined by those senior lawyers. We know that it is something that in one of our meeting, if the chairman of the bar communicates to members of the larger of the main body, it will go around, because some of the seniors sometimes they feel like, young lawyers, let me just align. There's no firmness in principle like your own person. So we don't mind situations like that. If such can be communicated to other members of the member body.
It's all right.
Thank you, sir. So there are instances between because we believe that courtroom exists one way or the other. It will feature advocacy. Now, in instances where there's more or less like a disagreement in submission between the judge and a lawyer, and the counsel is saying, I want to be on record, and the judge is refusing to put the counsel on record, what is expected of a young lawyer or a lawyer to do in that instance, so that the atmosphere would not be so heated up to the extent of throwing tantrums? Because there are instances where, okay, my lord, if you are not granting my application, I want to be on record, and the judge will refuse to put that counsel on record. What is expected? What do you advise that should be done in that instance?
No, if you are sure of your position and you know that it is a redundant point of law that will enable you to appeal, your insistence that you be on record it's not about tantrums. You see, you have to be pushful when you are sure of what you are saying and the way and manner you put it. Don't get annoyed. Chief Olujimi will train you. If you abuse Chief Olujimi from today till tomorrow, he will not even reply you. He wants to reply your point of law. You understand? There are times when people misbehave to Chief Olujimi and some of us get said, is something wrong with you? Why are you? He said he's doing it deliberately so that I will be taken off guard, but I will not allow him. You understand? So if you insist that you want to be put on record, it is your right. And if it is getting to the level of this abuse, you just keep quiet. When the thing died down, you say, my lord, I want to be on record. I want to be recorded. I want to be ruled against. I want a ruling on it. You can insist. There is no law that says you will not insist. The judge will not teach you how to do your case. That's how you want to do your case. So when you are firm and you are convinced about your matter, it does not matter. But you know, approach matters, manners. It's very important. That's why you have to be streetwise. Even in training your kids, let them be streetwise so that you know that there are so many ways by which you can say you don't know what you are doing without saying it. And it is a reflection of the training, the morals you have. Some people say you are acting stupidly. You don't need to say so. You understand? If you read some person's brief, they will now leave the this and begin to attack the judge because of what he has done. And there are so many ways by which you can dismantle the reasoning of the judge without any attack on his person. You understand? So approach matters, and the way we present our cases matters. It's very important. So if you know that you are you are convinced about a matter, you can press for a ruling. You press for a ruling, and the court will have no option um, other than to accede to that request. You can do clear. You just say, my lord, you just want a ruling. There is no problem about it.
Yes, sir. So another question: in one of our meetings, you mentioned one of our general meetings. You mentioned trying to highlight that there's going to be new criteria or conditions for applying for sick, and that one of it is that if that your judgment, if there is a word that is from the judge that is addressing your conduct during the course of proceedings, that judgment would not be countenanced as being qualified for the purpose of the application for sick. I don't know if you might. Yes. Now, would this condition, do you think, sir? The question is, would it not bring down the advocacy that we had in the time of late Olujimi Akeredolu Aketi? Like, for instance, where you want to you want to um, for instance, when you want to make submissions in total disagreement with the opinion of the judge, to the extent that you want to be firm. I want to particularly refer to an instance, but I'm trying to make sure that I couch it in a way that would not throw me off balance because of that. Well, okay, maybe you are saying to the judge that, my lord, yeah, you are pointing that, my lord, no, that cannot happen. That is not the position of the law. And while giving the judgment, although in your favor, the judge had put down derogatory words with respect to your conduct while conducting the case. Would this not bring down, would it not belittle the desire for advocacy in the legal profession?
Well, let me clarify certain things because I was involved in a lot of things that happened during Aketi. Before Aketi, when you see him in court, he gives courtesy to judges that he appeared before. The one you are talking about, the bar was combative because the judge wanted to sit on the judgment of the Supreme Court. That was during Ladoja, whatever. I mean, Court of Appeal had given judgments that Ladoja had been reinstated, and he wanted to sit, review the judgment. That was why Akeji said it cannot happen. It's not going to. There is not going to be black market injunction here. So it is about that one. And apart from that, maybe when the judges descend to the arena of conflict, it will have been apparent. That is when but in normal course, what they are talking about is a situation where some lawyers, in the course of doing their duty and gone forum shopping, had filed processes that ordinarily had delayed the matter, had done so many things that are
Okay.
uncalled for. Those are the things we are talking about. But they will also look at the comments.
Yeah.
In what capacity did they make those comments? If you see what our colleagues do in order to win cases at all costs, you will marvel. Because we have now seen cases as a do or die thing, that we must win at all costs. In fact, the reason why some lawyers have patronage is because they know how to win cases, either either by crook or by, so those are the ones we are talking about. We are not talking about standing firm when it is necessary, even in court. That's not what we are talking about. We are talking about a situation where there had been unwholesome practices. And some judges will not talk, but it is their judgment that will talk. That I need to deprecate the attitude of so and so, the way and manner he has handled this matter. Maybe has been tardy. These are the things we are talking about. You see this case where you say you are representing a suspect, and the lawyer sat. When the prosecution finished, you will say there is no cross-examination. You have read the case now. So they now pants on him after this thing, that is not worth being called a lawyer. He didn't assist his client in doing whatever. Will you now say that one had killed advocacy? It has also lifted advocacy. So these are conduct we are talking about. Or a lawyer that will not, the time he's supposed to come to court, he will not be in court. So those are issues.
Yes, okay. Thank you, sir. But also, how should a young lawyer take exceptions to derogatory use of word from learned seniors? Take for instance, we're in the same matter, and just because of an application filed by a young lawyer, there is all shades of words from the senior on the other side, stating to the fact that the lawyers of this generation have now. How should a young lawyer manage to take exception to those
I will
type
give
of?
you an example. When I was called to the bar, we had a matter in Lagos, Federal High Court, Lagos. The deputy, the DCR of Federal High Court, Ibadan now, his father was the judge that time. It was between Unilag and one professor, so we are representing Unilag. So we filed an application, filed a preliminary objection to the suit. The suit was filed by Professor Adesanya Esien that did Loge and Union Bank and First Bank. Professor Adesanya Esien was the one who taught Chief Olujimi and Aketi in Ife. So I filed the preliminary objection, and so when I went to appear, Chief Adesanya will come with his own car and his lawyers will drive another car behind him. He doesn't enter. So when he saw me, he was saying that I have come by way of the moral. I thought your two principals, I thought your this thing was. So I just said, my lord, I need the protection of the court. Okay, he was bragging. I just looked at him. So I came back. I said, Chief, it appears you are going to come and lead me. Oh, that this harassment. The chief said, even if it is FRA Williams that is on the other side, you are the one that will say, prepare your argument. I prepare. I said to Chief, look at it and send it back to me. So on the day of the argument, the man now stood up and said, I have come by way of the moral. I have this, I have that. I have a Supreme Court authority. I said, my lord, I also have a Supreme Court authority that says that I need not file a statement of defense. That was Elabanjo and Daudu. He said, shut up. I said, my lord, I need the protection of the courts, that I will not come all the way from Ibadan to be shut up by any lawyer, regardless of how mighty he might think he is. That I need the protection. Because I said, please, that was the way I was able to repel it. Maybe that would serve as a lesson.
Yes.
Say, shut up and sit down. I said, I will not. That I did not come all the way from Ibadan to come and shut up in this court. I will also argue my case. And so we argued. Unfortunately for Prof, he has not read Elabanjo and Daudu that time, and I won. That was the first case, test case that you won a case and you first call your wife and say, I won that case. Like Goliath and
David.
So I was so excited, so I cannot forget that case that I did with Professor Adesanya.
Despite intimidation.
Go by harassment, so garrulous. So since then, when we meet, he will call me and greet me. You understand? So, like I said, if you know what you are doing, if you know your cases, I was barely 2 years at the bar at that time, and you are talking about a person that taught Tifonu Jimmy and Aketi at OAU. So you can imagine how many years at the bar, Professor Chief Adesanya. So you can take the team back in a manner that will also show weakness on your part.
Thank you, sir. We are grateful for that practical example. Do you believe the current disciplinary sanctions are strong enough to deter unethical conduct in court? The current disciplinary sanctions, you believe that it would help to deter unethical conduct in court going forward?
Well, as far as I'm concerned, I think that most of the sanctions are slap in the wrist, as far as I'm concerned, and that's why we have not been able to cope. I think we should try and go a step further and delete people's name from the rules. There are some people that are not supposed to come back to this profession. They have been so. If you see what we see in disciplinary panels here, people that seem to be old lawyers who are not even supposed to be in this profession any longer. And we must, as a lawyer, be courageous enough to expose people that are not fit and proper to continue this job. Most of the time, hypocrisy is too much. Even when you say, hey, some people will go and meet them and say, and that's why I tell people, I am not afraid of being quoted, but don't quote me wrongly. Tell them what I have said, and I can. So, as you see me, I don't backbite. I will tell you to your face. So, whatever I say behind you, I will say it to your face. In fact, I wait till I see you so that I can say it to you, so that nobody will come and tell you that I said this. I don't. But I have discovered that a lot of hypocrisy. People will do wrong, and you follow them to come and beg. Why do you have to beg? Lawyers who understand the law, who knows the consequence. Somebody was telling me of a guy, this remuneration thing, said they now inform the client, pay the correct fee. When they return my money, I will return part of the money to you. Pay 500,000 to the bar. When they return the money, I would send 200,000 back to you. Don't worry yourself. So how do we help lawyers again? Somebody just told me, and I said I am keeping my eye on that person. And I have, that I have always been making this statement. I begged those seniors that anybody that is found culpable in this matter, don't come and beg for that person. You can wait till I leave. Maybe another person that will take over, you can go out, but don't come to me. I'm just getting that information. And so you can see. So when I say that, but they say, so if he thinks that he has wife and children, why will you go and do the unthinkable? All of us love money now. I also want to be a rich man. But because we know that there are certain level we cannot get to, we are contented with the torokobo we are having. But we know that one day too, we will also get money. You understand? So we need to, as a body of lawyer, know what we want and be determined to rid our profession of bad eggs. We know them, but we don't feel we should expose them. We don't feel say I don't want somebody's life to spoil in my own hand. Yet the thing will continue to degenerate, and all of us will suffer it. That is the truth.
Thank you very much, Chairman, sir. I want to ask again the principle of appreciating the court if the judgment is for or against you. Is it practice, direction, or tradition? And if it is not observed by the council, the judgment is against, is it a breach of any ethics in the profession?
Well, it is not, but I think that it is recommended that even when you disagree with a judgment, you can still thank the judge for the industry. At least you know you go to the next whatever. It is not a practice direction that in fact there are some judges that will tell you, why are you thanking me for my job, for the job? But you are expressing that in the interest of justice, that whatever it is, whether it goes in my favor or against me, it does not matter. It is just cause of justice, and I will go and ventilate my views. In fact, thanking the judge shows that you have no personal attachment to the case, that you have done your case and he has done his best. So we'll go to the next whatever. There is nothing wrong in thanking, and if you don't thank, nobody would hold you for it.
Yeah,
But it
thank you.
shows when it shows that you are not emotionally attached to the case.
Yes. Yeah.
You know that some people will do cases and they will not speak to their colleague again. But on the other side, I've seen it too. Somebody was telling me at Kilorúkọ court ọ̀nà Ìjàyè, Mọ́níyà. Shaina was telling me that he had cases with Láìdé tó máa ń sọ wúruwúru lórí kíní ẹ̀. Since then, that he has even greeted him today, he refused to answer. I said, leave him now. Is it compulsory that you must? So there are some people that will take you as enemy because you did the case together.
Yes.
So it's a question of how exposed, how knowledgeable you are as a lawyer.
Yeah, thank you, sir. We are grateful. Also, to also ask, there are instances, also to ask whether it's a practice direction, a law, or a tradition. Instances where fiduciary relationship or some sort of intimacy or emotion is being sensed between a legal practitioner and a judge. And in most cases, there's always a decline, a refusal from that judge that the case should be reassigned. But what if the intimacy or the physical relationship is known to the other counsel, and then that proceeding proceed, and the judgment was in the favor of the lawyer who actually has that relationship, or that relationship with the judge? What is the effect of that judgment? Is it a principle or a practice or a law that that judge, if she's aware or he is aware of that physical relationship between herself or himself and the counsel, that he has to resign, he has to request for the assignment of that matter?
Well, you know, it's about it borders on the personality of the judge involved. If it is a judge with integrity, nobody will tell you before he will recuse himself if you have matters before that judge. And when you talk about fiduciary relationship, I don't understand what you mean. No. You cannot say because Mr. Adebola Salami, judge, had been in the bar, he has been our friend, and we cannot do matters before her. We are talking about filial relationship. This person is the daughter or husband of so 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 and so, and the matter, the nature of the matter will mean that I won't be spared of, so he can on his own says that he want to recuse himself. The judge might not think that the knowledge they have will affect his decision on this matter. If the other party is not comfortable, he can raise it and say the matter be taken away from because of the relationship between this person and this person. Why not alleging that there will be bias, but in the interest of justice, let the matter be moved. So if the other party feel comfortable and the matter went on, it will be wrong of that person to come back and say because they are related, why did you not raise it? That is laches and acquiescence now, Abi.
Thank you very much. I like to
So
differ.
the other one, if the other party sense that there might be foul play, let him raise it at the earliest possible time.
Thank you, sir. I believe that Mr. Epong, before I continue with the last batch of questions, I have a few questions penned down for the chairman. Please proceed to ask so that.
Although you have also asked questions, because I want to ask, when you started this interview, you mentioned that this our profession is one of tradition, and the tradition we met at the bar, and that is still on at the bar, is that when you go to the high court, you must be ruled, fully ruled. Now, while I was in the university, we've had arguments about whether the robe should continue. What is your position on that, sir?
The rope.
Yes, whether we should be removing our robe when we appear at the high court, or we should still continue using the robe. Do you get my question?
I do. As far as I'm concerned, I don't see anything wrong with the rope. In fact, it makes us different from any other person. They will tell me that even where we got it from, they don't rope anymore. But if it will make our adherence to, in fact, it is even the roping that is still reducing the way and manner we dress. By the time you remove the rope, you are going to see a lot of. So, do we also adhere strictly to dressing codes here? No. So I think we are not ripe enough to remove the rope, as far as I'm concerned, because of what we have seen, even under the rope. So I do not follow the crowd because they have done it in so many climes. We must do it. We must look at ourselves. That's why more often than not, I laugh when people say in advanced country, in Sena climb, they did this, they did. If anybody has in the Sena climb, if there are accidents, there are things that they will do. Here we will be filming the victim. We will steal their phones. We will do all manners of things. That is who we are in this part of the world. So, as far as I'm concerned, I don't think we are ripe enough to remove the rope. In fact, people will come to court with pants if care is not taken. It is still the gown that is covering a lot of, if, especially female. If you see what they put under you will marvel. You will marvel. So me, I don't want to. Yes, I'm an activist too, but when it comes to the realistic approach to issues, we are not ready.
Thank you, sir. Yeah. From your personal experience, what are the common courtroom pitfalls that lawyers should look out for and how to avoid them? Common courtrooms and how it should be avoided by young lawyers, generally, the ones that should be looked out for and how to avoid them.
One of the first pitfall is getting to court late. A young lawyer must avoid it. You must be in court promptly. You have matters by 9. By 8:30, you should be in court. I've had occasions that I had to wait for my juniors in court. That's why I don't give them my file. Say, oh God, will take the file. Say, Laye, because you get exasperated. So that's one of the pitfalls. The second one, because you will not come to court early, you might not even know where the position of your case, whether you are in number one or you are in number two. A lawyer who comes to court early will demand for court list and know where his case is. You can also use the opportunity to talk to the lawyer on the other side and agree on certain things. You understand? 3, one of the pitfall is that a young lawyer must avoid is his inability to read our files, understand the case he's coming to do in court. Those are the things. 4, you must not at any point in time disturb the court proceeding, either by your conduct or your absent-mindedness. Another pitfall that you must also avoid is a situation where your dressing gives you a way as an unserious advocate. You see a situation where what do you call it? You'll be falling off a lawyer's while addressing the court. We have seen it. So appearance is very important. Concentration in court. Follow the court as the proceeding was going on, whether it is your proceeding or not. Rapt attention, because you never can tell whether what has happened there will happen to your case. Those are the things. Unnecessary distractions are pitfalls that a lawyer, not only young lawyers, should avoid. A lot of your people will even be chewing gum self and be in court and be chatting. She does not know what was going on in court. She was just there. These are things that lawyers must avoid.
Thank you, sir. We are the language of "this is my court" only commonly used by judges. This is my court. This is how I want to do my thing. Is it appropriate, or would it qualify as not being in compliance with courtroom ethics? So this is my court, Mr. Lawal. Please, your application. I'm striking it out. Go and do this as
It
a
is his court now. A judge should be in control of his court. Have you not? Even in the rules of this thing, it is the court must be. The court must be in control of his. The judge must be in control of his court, and they have told you several nature of judges. You have loquacious judges. You have taciturn. There are some judges that even when you are making wrong submission, you will not see it in their
they're
face.
counting.
They'll just be looking at you until
You're ruling.
there are some judges that will say, no, what are you talking about? These are loquacious judges. It does not affect whatever they are doing. It's like we are created differently. We have different nature. You cannot expect the same standard. But what is important is that has justice been dispensed? That's what is important. Is there justice at the end of the day? There are some 9 o'clock judges. God save you if you are before Adeyemi's court and you are late, or even Salami's court. He will sit exactly 9. There was a time we were there before now. TJ them. They took my file. I would have carried my file to court. My case was number 1. They called that case. I didn't see the file. I said, my lord, and I said they went to change. I said, what kind of nonsense is this one? Dress when you are going from home. You don't need to now come and so things like that. And you have judges that you have to stay till 10 a.m. before they sit. So is it not his court? So there is nothing wrong in saying this is my court. This is what the judges set rules of procedure most of the time. I'm not talking about procedure in that is in rules of
Rules
court.
of court.
No, we are talking about the court management. The court management. There are courts that will say, this is what I want, this is what I want, that you cannot now, there are some judges that will not mind. If you file today and enter their file, they will hear your matter if there is no opposition. There are judges that will say, lie, that just file today, it will not enter my file. So style, let me put it that way, style. And you cannot expect the same level of behavior from judges.
Thank you, sir. We are very grateful for that hint. Conclusively, wrapping it up,
Well,
as the chairman of the YLF-NBA Ibadan branch, what is your advice for the young lawyers on monitoring professional boundaries and integrity in the courtroom, and your message to the next generation of lawyers on the importance of upholding the courtroom ethics?
well, I want to say that young lawyers who are the gatekeepers of courtroom ethics now should strive hard to put it into practice, not just observing it. They must also practicalize it so that they will have things to bequeath to those that are coming behind us. Legal profession must be protected by all and sundry. And the best way we can protect it is to ensure that those morals, those rules, those ethics that are being handed down to us by our forebears are not put in jeopardy. We must go back to that pristine time where lawyers' words is bond, where lawyers do their cases with utmost diligence, and where we see justice not from a side, but for justice for all. Until we go back to that, we continue to lose respect and regard from the public. Let us rededicate ourselves to this profession and ensure that we do what is right at all times. If we do that, we can be safely described as gatekeepers that want to bequeath what is good for the generations coming behind us.
Thank you, sir. Quickly, lastly, I want to, as the chairman of the bar, the premier bar, known for distinct practice in the courtroom and outside the courtroom, we understand that there there are instances, or we have had cause. This administration had cause to constitute ethics and dress committee, and letters have been written to the magistrate and the high court. Particularly at the lower court, we still have members of the forum and members of the bar not complying with this dress, this dress, and we know that the best way that this can come in place is through enforcement, and that can only be done by the bar. Can you please just give us like a form of undertaking, ensuring that there will be enforcement with respect to this, so that the legacy as a chairman of the bar, Mr. Ibrahim Lawal, we can have recourse to it to say that yes, he brought back the principle of the standard dress code within the premier bar jurisdiction.
Well, let me start by saying that enforcement of dress code is a collective responsibility. Ibrahim Lawal will not be in every court. And these are things that you will notice in courts. And I want to give kudos to some of our seniors who insist when they see wrong dresses and say that, my lord, this person cannot be had. We have said it repeatedly that if we all agree that we must sanitize the bar all of us must be the enforcer. There is no number of committees that you will set up, except you are saying that they are there full time, they will not do their own job or their own work. Lawyers are very busy people. But when we agree to sanitize this, anyone that is available in any court, if ESCO members are there, you should rise up and challenge it. Senior members should also do. And if you are there are so many people that I have told at the magistrate court that you cannot appear because you had no socks, and there is nothing that will happen. But more often than not, our magistrates and judges are doing the job for us. So it's not even about undertaking, it's about telling you that we have started. And so if we see few numbers, it is also your responsibility and others too to also challenge them. It is not the job of the senior lawyers alone. Even you who are young lawyers should also challenge your colleague as to the proper mode of dressing. And like I said the other time, I said our inability to call a spade is what is affecting this profession. We will see what is wrong, we will just put our eyes away and say àwọn bar, as if all of us are not members of the bar. So it's not about giving any distance, it's about all of us resolving to enforce it. But I can assure you that enforcement will be more harder this time. It will be harder this time around.
Yes, sir. Thank you very much, sir. We are grateful, and we believe that young lawyers would have learned or would have been well abreast with the courtroom ethics that you have shared insight on. It was indeed a very wonderful interview session, and we thank you for your time, being a very busy personality. And I'd like to appreciate Mr. Epong, the chairman of the Board of Legal Assistants, Ms. Bolawere, the PRO Publicity Secretary of the Forum, Mr. Kayode Karim, the Treasurer of the Forum, Madam Feyishara Ajao, the Secretary of the Board of Legal Assistants, Mr.
Madam Miss.
Miss Miss Feyishara Ajao, the Secretary of the Board of Legal Assistants, and Mr. Ono Shola Lukman, one of our crew, who was also here. Thank you for your time. We are grateful, and we hope that we can always have you again. Thank you, and God bless you.
It's my pleasure.
Yes.
I also congratulate the Young Lawyers Forum for adding value to the bar. Because this kind of program is also adding value and also doing the work of the Bar Association in a way to also sensitize our members as to what is expected of them as a budding legal practitioner. So I thank the Young Lawyers Forum and send my regards to your members, that I am pleased with what you have done on this thing, not everything. So God bless you.
Amen.
Thank you.
Thank you very much, sir. We're grateful.